Good evening and thank you for joining us on Sunday Interview. I am your host, Grevazio Zulu. Now, on Tuesday last week, Zambians witnessed a landmark judgment in which the Constitutional Court delivered its final verdict, ruling that former President Edgar Lungu was not eligible to stand as presidential candidate in 2026 and other future elections. Earlier, judgments made in the case by the court were vacated and a new precedent set for future reference. The judgment has been welcomed as a critical step towards safeguarding and preserving the country's constitution and democratic principles. But for some, it has brought out inconsistencies that threaten to erode the confidence of the judiciary. On the program today, we reflect on the judgment with Mr. Wynter Kabimba, who is former Justice Minister. He's a seasoned lawyer with 40 years' experience at the bar. Currently, he serves as president for the Opposition Economic Front. Mr. Kabimba will discuss other national issues that include corruption and, of course, the economy. We will open the lines later on in the program, and as usual, you can participate in the conversation by calling 25 30 25. Mr. Kabimba, it's nice to have you on the program.
Thank you, Grevazio, and good evening, dear viewers. Well,
we have been, as a country, on this case for close to 8 years, if I'm not mistaken, debating, petitioning, defending, and counter-defending, and of course ruling, with the judgment out on December 10th. Would you say now that the case is finally settled?
It's the hope of everybody, Grevazio, that this issue of the eligibility of the former president has got into its final stage. That the judgment by the Constitutional Court on the 10th, on Tuesday of last week, brought to finality this long outstanding issue in our country. So my hope and the expectations are that we can move on now to other important national issues, that will do or develop the welfare of the Zambian people.
Let's summarize the document. I know it's a bulky document, and many watched and listened, but they probably didn't delve into the detail. What is the difference? What is the difference between Tuesday's ruling and the 4 judgments delivered in the past?
Delivered previously.
Yes.
Well, I took time to sit through the judgment in front of the television set, because I wanted to listen to the judgment from the beginning right up to the end and get the salient points. The takeaways are as follows. First thing was the position taken by the Constitutional Court that they had the jurisdiction, they had the power to revisit their previous judgments, especially the Danny Pule judgment of 2021. That was important because the Supreme Court of Zambia and the Constitutional Court have in the past been extremely reluctant to go back to their past judgments. And that has been a long-standing practice. In fact, I can tell you that in my 40 years of practice, I can't remember a case before the Supreme Court where the Supreme Court has been persuaded to go back to its decision. So that in itself was a landmark position taken by the Constitutional Court for now and into the future. What also that meant was that the men and women of the Constitutional Court were humble enough and they were courageous enough to say to the Zambian people, where we think we were wrong, we shall right that wrong. Because the arguments, excuse me, the arguments that were raised by the first respondents advocates, ECL, that you can't go back to hear this matter again and redetermine it, because you have already done so. And under the principle of res judicata in law, which in short says, look, if we have the same parties, if the same parties went before same court with the same facts in a dispute, and a judgment was delivered, they can't again come back to that court as parties with the same facts and hope to be entertained by the court. So what the judges did in this case is to give a much broader interpretation of the principle of res judicata.
The issue of finality. I look against it. And that's one of the arguments that is currently in the public domain.
Yes.
One of them, state councils, John Sangwa and Grevazio Zulu, have all referred to it and have used the phrase to say you can't keep on pounding and pounding or beating and beating the court until it gives you a judgment that you want.
Yeah, but that's, but, you know, that may not be very correct. Because you see, a case that goes before a court of law has mainly the parties to that case to do their research and persuade the judge, or in this case, the judges. So the onus of doing extensive research so that all the facts of the case are brought before the court and all the relevant provisions of the case, or of the law, are brought before the court is on the parties, more than the judges or the judge, if it is a single judge. That's why in law, we always, you know, you always hear this phrase which is say, where the judge says to the parties, I've listened, you know, to this side, and I've listened to this side. I'm not persuaded by the other side that this is the direction that I should take. I've listened to the arguments, I've listened to the provisions of the law, I'm not persuaded. So law is a skill and an environment where you persuade the court. And the way you persuade the court, the onus is on the parties to ensure that all the provisions of the law are brought before the court. What the court said on Tuesday was this: yes, we determined the Danny Pole case. Yes, we found in favor of the first respondent, and we said that Edgar Chagwa Lungu is eligible to stand in the election in 2021, and hence his candidature in 2021. However, there are certain facts which were not before us in 2020, 2018, 2020, up to 2021. There are certain provisions of the law that were not brought to our attention during that period, and we also didn't find them we didn't refer to them during our research. And these provisions, this situation taken holistically, has persuaded us that we must go back over this matter, go back to the facts and rehear the matter this time around. And they did that by convincing the citizens of this country that this is not only being done in Zambia. This is not only being done because we want to do it. In fact, it has been done in many other jurisdictions around us. And they went to list those jurisdictions. They quoted cases in South Africa and other countries in the Commonwealth. So the point they were making is to dispel this this notion, this perception in the minds of many people, along with the argument that was presented by ECL's lawyers, that they are doing this when they do not have the powers to do so.
What did they use? What powers did they use? Did they use the law? Because
they use the
other legal minds are saying there's no law which allows the Constitutional Court to revisit its decision, to review its decision. That law is restricted to the Supreme Court. Did they use just precedent, or they use the law to come to that?
Look, Grevazio, every case in court has two parties. So we can continue with this argument that this is what one group of lawyers says and what is and that the other group of lawyers says this. That's why the case has two parties. Okay? But what the point I'm making here is that the Constitutional Court was very clear, and it tried to acquit itself out of that position and say, by saying that this is not something new. What we are doing is not new. Even in the legal profession, it's not new. So if you want to split hairs that, it can't be the Constitutional Court, it can only be the Supreme Court, yeah. That's a different argument. But why not the Constitutional Court? Because the Constitutional Court is the court that is vested with powers to interpret the Constitution and make final decisions on the or provisions of the Constitution. No other court. The Supreme Court is not vested with that power. So if you are not happy, if the Constitutional Court doesn't do that, you have nowhere else to go. So I strongly believe, and I'm persuaded by the arguments myself, or rather believe, in the position taken by the Constitutional Court, that what they did was actually correct.
To revisit the decision.
To revisit the decision.
You're calling it correct, and you're saying calling it a landmark.
Yes.
And magnanimity, of course, magnanimous. But this is also being looked at as a weakness in some quarters. People are saying this now shows instability.
No.
At judiciary.
No.
Laz also says, well, urging citizens to respect the judgment, but they have concerns around that they call potential risks of fluctuating decisions of an apex court.
No. If you sat through the judgment, the Honorable Judge, Deputy President of the Constitutional Court, was reading the judgment, took time to walk us through the provisions and the reasoning of the court on why this case had to be reheard. And I think the court was very clear in that respect. But let me move away from that, if you allow me to do so, to go to the other aspect of the judgment, which has been a takeaway. The Constitutional Court said, one, that ECL is not eligible for nomination or election as candidate in any future election. But they didn't stop there. They said he also is not qualified to hold the office of president in the future. Now, these two sound like they are one and the same thing, but they aren't. They are not. To be nominated, to be eligible for nomination as president and to be elected as president is different from being disqualified from holding the office of president. But the two positions have roots in the same clause, the same article in the Constitution.
106.
The article to the effect that he has twice been elected. Okay? Now, that is important because if you think that Plan B is about ECL
being a running mate,
and getting the elected president resign, dying, or being impeached.
Would any elected president do that? And resign to give to the power to another person?
No. But
far-fetched.
It's hypothetical. But I'm just trying to clarify this point why this other limb of him being disqualified is important from holding the office of president. The fourth issue that I would like to canvass here, Grevazio, is the issue of the
maybe I should take you back to the issue of the running mate.
Yes.
Is that grounded in law that you cannot stand as are the qualifications for a running mate similar to that of a president?
Yeah,
it's presidential candidate.
It's actually implied. It's actually implied. When you read the qualifications of president, okay, when you read the qualifications of president and those of vice president, it's implied. It's implied that the person who is going to run as the running mate must have the capacity, must be eligible to take over as president in the event of any contingency of the position, the office of president falling vacant. It's implied. Okay? And it's very clear that you can't be a running mate if you do not have the capacity to take over as president. Because we have twice been elected. I don't think there is even any argument there. So it can't be plan B.
It can't be plan B.
No.
Let's look at the other takeaways that you use.
The other takeaway, you know, is this. That the judges were sending a clear message, especially to us, the politicians, that look, you will be wasting your time if you think that you are going to arm twist us through propaganda on social media, through your public statements. If you think that you are going to arm twist us to deliver to you a judgment which you think favors you, you are wasting your time. So they exhibited great courage. Because there was a lot of social media, no, there is tension in the country, no, this is going to divide the country, no, there will be a lot of protests, you know, if the Supreme Court, you know. And the last statement, I think, was from ECO himself, which he was quoted in the mast, that the judiciary is on trial. The judiciary was not on trial. The judiciary has had a job to do, to deliver justice.
Well, there are
So
concerns
I like
when you say that, there are concerns there. Somebody was saying, look, this is a political judgment. Doesn't it raise concerns that two decisions are made in two different regimes over a political case?
No, I don't think the difference should be
tied to regimes,
but tied to administrations. No, I think the judgment. I think the difference should be tied to the quality and the reasoning in the two judgments. Okay, we look at judgments of the courts in terms of reasoning. We don't look at them only in terms of the declarations made at the end. The reasoning is also important. And I think this was a well-reasoned out judgment.
Does this judgment, in your eyes, give you confidence in the Constitutional Court?
Yes.
I know some time back you wrote very negatively about, well, it wasn't direct, but you said the Constitutional Court, since it was established, has always made decisions that have raised a lot of debate and dust.
Yeah, in fact, you are right. In 2021, when they delivered the Dan Pule judgment, I made a statement that that judgment was wrong. In 2021, when
you referred to that judgment, you referred to the Kambwiri judgment and three other judgments.
When ECO, no, let me deal with this because this is relevant to this. When ECO was still in power as a president in 1991, I made a clear statement. 2021. I made a statement after that judgment was delivered that that judgment was wrong. I didn't agree with it, but I said as a lawyer, I would respect the judgment because that's a judgment of the court. I've been vindicated.
Here's an argument by the defense that nothing has changed from the four other judgments apart from the people that sat at court and the Attorney General.
Look.
Do you agree with that judgment? It's there in the public.
This matter, look, there are also people that disagreed with the 2021 judgment. So why is it so peculiar that when others now disagree, you know, with that judgment and agree with this judgment, then it becomes something peculiar. Why is that so? There are those of us in 2021 who disagreed with the Dan Pule judgment. And we said it publicly. And the people that are now saying this is a bad judgment, they accepted that as a good judgment. And those of us that are citizens of Zambia and respect judicial orders, we respected that judgment. So I expect anybody now to respect this judgment as well. So to argue that, you know, this is democracy now, democracy is not a relative. So it was democracy then, it is democracy now.
You supporting the judgment needs to convince the people when they say nothing has changed, apart from the people at court.
You see...
When you read the judgment, what has changed?
When you use the word people, you must be extremely careful. Because you can't pick on 3-4 lawyers and and pick their argument and disagreement and refer to them as people. The people are here in Kalingalinga. The people are in Mulenga compound in Kitwe. The people are in Shangombo. The people are not those of us, the elite, that speak to matters like this. So when you use the word people, you must be very careful.
Let me use the word the legal team for ECL.
Yes.
And I used it earlier, that the defense
said
that nothing has changed.
They've got the right.
It's just the people at court.
You look.
And the Attorney General. So maybe you read the judgment. What has changed?
What has
from
changed?
The ruling in 2021?
What has changed?
And the ruling in 2024?
What has changed is that the courts now, or rather the court now said there are provisions of the law that we didn't take into account at the time. Now we are taking them into account and we are changing our position. That takes courage, that takes humility. And I think the men and women in the Constitutional Court should be given kudos for that, instead of condemning them. Okay? There was an injustice in 2021. There was a wrong which we need to right, and we have taken it as our duty to right that wrong.
Which part of the Constitution was relied on? We need to unpack the judgment. In the Constitution, which part was relied on as the information that was not available at the time? The other judgment.
I don't have the judgment here, but I remember the judge referring to Article 2. I remember the judge referring to some section in the Electoral Act. I think he listed the sections there. He did. And he said these were not taken into account.
There's an argument here again that, well, there's a real fear, of course, that the court now has opened itself to persistent petitions by doing away with the concept of res judicata.
No. Look.
Meaning the other guys, the other team, can still go back to court and re-petition.
Yes.
And they should be heard?
Yes.
In your view, they should be heard?
Yes, they've got the right to do that.
More drama?
They've got
endless drama?
No. But this is
the highest court, and then
Grevazio,
people keep on going back there and say, well, I think you forgot this. Can you reopen this case and hear it again?
But if you took time to read, the judgments in the English courts, going back, in the 1500s, where this concept, this principle comes from. Judges, the courts have done that. They are not timid. They are not shy to do that. Okay? If they want, they can go back tomorrow and say there is a comma which you left, or there is a full stop that you left, and the court will hear them. Just like they were heard when they raised, the preliminary issue that this matter is res judicata. They were heard, and the court ruled, saying that in our considered view, this is a petition we should hear. This is a petition which should not be stifled by the principle of res judicata. And in their final judgment, instead of leaving that ruling on res judicata on the preliminary application, they included it in the judgment and reasoned out why they were walking away from the principle of the doctrine of res judicata.
Let's move on. The ConCourt decided to vacate its pauses past 4 decisions, indicating that former president was eligible.
Yes.
But shouldn't they have gone further? There's another argument, school of thought. Shouldn't they have gone further to decide that he wasn't eligible to study in 2021?
No.
Because that was another judgment made in error.
No, they covered it.
Didn't they make that decision in error? They did, no?
If I listen, they said we made it in error. They said
they should have vacated it.
They acknowledged that. What the ConCourt said was this, that look, the 2021 decision, to the extent at the time that it was our judgment, it was law. And therefore, ECA contested the elections of 2021 under a legal judgment delivered by this court. At the time, they made it clear. I sat through that judgment. So they dismissed the relief, or rather the 2 or 3 reliefs by the petitioner, on account that you can't say that, or rather will not agree with you that because now we are saying that that judgment was wrong, therefore the emoluments paid to ECL were unlawful, etc., etc. That judgment was law at the time, and so that judgment only expired on the 10th, last Tuesday. From that date to Tuesday the 10th, it was law. They covered that.
There's an argument from the opposite side. I know you're saying it would be an endless judgment. They're saying maybe they should have vacated that decision as well.
No.
Because it was also a wrong judgment. They should have said, well, we're vacating this because since we made a wrong decision, it was an illegal
no,
person on the ballot.
That's not how res judicata works. That's not how the principle of res judicata works. It works on the principle that the first judgment, to the extent that we didn't take into account other facts or other provisions of the law, is still valid. It is still the judgment, it is still the law. Like I've said, that judgment was running as law from 2021 when it was delivered up to Tuesday, the 10th of December, 2024. It was the law of the land. It was the correct interpretation of the ConCourt. And therefore, ECL was nominated and contested the elections and a judgment that was lawful. Is that very difficult to understand? No, I don't think so.
You were picking out highlights of the judgment. I want you to give a broader picture to it. Well, if let's go back again, maybe to your question. Suppose he had won 2021.
Suppose he had won the 2021 election, and then this judgment.
Would we have had this case reopened?
No. That's let's not be hypothetical. I think the ConCourt was dealing with the facts before it, with the practical situation. So if we are going to get into a moot court, then the arguments will be endless. I think what happened in this case is important. One citizen, just like Danny Pule, as a citizen in 2018, went to the Constitutional Court. In this case, another citizen went back to the same court. So Danny Pule had every right in 2021 to go to court. Michelo Chizombe has the same right as Dan Pule to go to court. What is good for the gander, for the goose, is good for the gander too. What is good for the goose is good for the gander. Why is it right for Dan Pule to go and petition the court, and he is not being used by any politician, and the president has no hand in in his petition or in the judgment? But for Chizombe, there's a hand from the executive, there is a hand from the president. I don't think that's how democracy works. I think what we ought to do is to respect the rights of every citizen. I respect Dan Pule's rights to go to court. I equally respect the rights of Michelo Chizombe to go to court. And what has happened in this case, in the present case, is that the Zambian people have accepted the judgment of the court because they respect judicial orders of this country. Otherwise, we would not have a stable country.
There was a school of thought that probably Edgar was targeted. And this is coming from lawyers. Some of them argued that it's unprecedented and probably unprocedural that a losing candidate was being petitioned.
No. Look, they had all the rights to bring up those arguments before the court of law. So we ought to separate what sounds like a political argument / legal and the legal argument. When this petition started, the lawyers for the first respondent, or all the lawyers for the respondents, had every right to bring all the arguments, including the ones that you are listing, which are being, enlisted by other people. They are citizens. They could have joined the case. They could have joined the team of lawyers. But to try to prosecute, you know, the matter after the judgment, post-judgment, and say that this is what should have happened, this is what... No, what should have happened has already been pronounced by the court. There's a judgment now on our hand, and that is the law. Just like in 2021, I argued that, you know, this judgment was wrong. That was my opinion as a citizen. It was my opinion as a lawyer. But he didn't have to change the law. He didn't have to change the judgment of the court. If I wanted to change the judgment of the court, I should have done what Kizombe has done.
Go back.
Go back to court.
The Tonse Alliance, the opposition Tonse Alliance, is insisting that Mr. Lungu will be on the ballot come 2026. They've hinted to a plan B, which of course no details have been shared around that. Is there a possibility he can get back to the ballot? Not within the context of the December 10th judgment and the provisions of the law as they exist now. No. There's no plan B that can upset that judgment within these parameters. In fact, when I watched the Tonse Alliance, you know, press conference, I thought they were just joking. I thought they just wanted to say something, because they are the supporters whom they had given the impression, you know, or that ECA will be on the 2021, you know, ballot. They had campaigned, you know, through, you know, social media. They got their self-styled human rights activists and political analysts, you know, every day appearing, you know, in some tabloids, you know, on your social media, you know, and really giving the impression that the ConCourt is fettered. But not only that, even trying to intimidate the ConCourt judges there. That this country will be on fire unless you find in favor of ECL, because it's so popular, you know, that, you know, what we saw on the 10th of December was a holiday. The country was so quiet. I remember talking to a friend of mine the day before. You know, they said to me, "What do you think about tomorrow?" I said, "It's a holiday." And it was indeed a holiday. Because I understand the Zambian people. I saw this with KK in 1991, 92. I saw it. Okay? When we thought that if UNIP loses an election, there is going to be war in this country. In fact, if you remember, Nevas Mumba had predicted, he said he had a prophecy that there will be bloodshed after the 1991 election. That was his prophecy, that God had told him that there will be bloodshed. He was wrong. He didn't receive anything like that from God. That was peace. So even this time around, I was very confident that once the ConCourt delivers its judgment, one way or the other, the Zambian people will respect that judgment. That is what Zambians are known for. They may have their own frustrations about the judiciary, but they respect the judgments of the courts. I'll get to that. Maybe let me get to it now.
Yeah.
You've talked about Zambians respecting the judgments of the court. But then here comes, I want to quote, I think, Makebi, where he was saying, the fight is not over. This is a fight for the heart and soul of the country, which is the judiciary. I don't know whether he was speaking for himself or on behalf of them. There seems to be a perception from these statements that come in public, that there seems to be a perception that the judiciary seems to suffer from infiltration and intimidation from the executive. You were a justice minister at some point. Is this what you witnessed?
You ask a very good question. Okay? But let me start from this, from this premise. If my colleagues who are alleging that are right, then they must own up to the nation that that is what ECL did. Because that argument cannot only be limited to the judgment of Tuesday last week. So the way I hear that argument is that they saw it happen and they think that is what is happening now. That's a danger with that argument. But let me tell you this. When Mr. Sata was in office, and you can verify this, when PF won in 2011, I think we had taken out something like 30 petitions, election petitions. We won a good number of them and lost a few. The person who was telling us, the lead counsel in the PF team, was Bonaventure Mutale, State Counsel. And when the judgments came out, we either heard from Bonaventure Mutale, who went to the president, and the president phoned me, or he came to me, and I went to brief the president. You can ask any judge during Michael Sata's era. No judge ever received a phone call from Michael Sata.
And from yourself?
The only person that I saw the president discuss a few things with was the Chief Justice, Balombechi Besakunda. You can go to the judges. No judge ever, at the time, ever received a phone call from me. The only time when a few judges received a phone call from me as Minister of Justice was when I was talking to them as to whether or not they would want to be elevated to the Supreme Court, or they didn't want to go to the Supreme Court. I had to discuss with them. And when they gave me the answer, yes, I'm willing, I went back to the president. They never spoke to the president. And there were very few, 2 or 3. So I can vouch, for Michael Sata. He never did that. I can vouch for myself. Let me give you this example. When Brebna Changara and Lucky Mulusa went and moved the tribunal against me, and a tribunal set up, chaired by the Honorable Judge Hamaundu, whom I worked with at the council, at the Lusaka City Council. I never picked up a call to speak to him or any member of that tribunal. Never. And he's there. You can ask him. So I've been in this situation. So when I hear dangerous statements like that, then it means there is something that you know that others don't know.
So you're vouching for the independence of the judiciary?
I'm vouching
over the regimes.
I'm vouching for the independence of the judiciary. In fact, I can tell you, I can go back, to UNIP. If there is a time when the judiciary should really have been compromised, it was during the one-party state. But I was in court in 1981, when President Chiluba was admitted, to bail by Judge Moodley after his arrest over the protests on the Copper Belt. I was in court. I attended the Edward Shamana and others treason case, and some of them were acquitted, and some of them were convicted, and subsequently pardoned under the one-party state. So maybe, we are talking about issues without the historical context to them. I've been there myself before.
You've heard the growing cries from the opposition that probably the judiciary is getting compromised.
Look, the opposition can say anything. I'm in the opposition myself.
Meaning you can say anything?
Yes. The opposition in Zambia can say anything. But that does not mean that what the opposition is saying is true. Okay?
That's how you dismiss the statement.
What else can I say?
Let's move on. Still on the judgment. What are the implications and lessons that can be picked from this judgment?
Look, the implications that can be picked from this judgment are as follows. The implications are as follows. That when a citizen is aggrieved, they must be allowed to go before a tribunal established by law, in this case a court of law, and they must be allowed to be heard. And the court must be left with the liberty to deliver a judgment. What I've seen, or what I saw in the period running toward the judgment of the ConCourt was sad. It was sad. It was not right that we should intimidate the judiciary. Mm-hmm. We should support the judiciary to arrive at the correct decision.
Okay. Welcome back. You're still watching Sunday Interview, and today we're talking to Economic Front President Wynter Kabimba, who's looking at the eligibility judgment, and later on he may be discussing issues around corruption and the economy. Before we leave the issue of eligibility, yes, is this a time now to think of focusing on mending the Constitution to address the lacunas? No.
You know, there has always been this argument that when you have a controversy like this, therefore you must amend the Constitution. No. Because sometimes what we are dealing with is just a misunderstanding amongst ourselves as citizens. What is clear in this case is that there is a polarization between those who think that the ConCourt should not have done this, and those of us who think otherwise, and you know, that kind of thing. And that is normal in a democracy, Grevazio. There will be no democracy if you don't have divergent views. And divergent views by one side does not mean that, you know, when you have divergent views from this side, does not mean the other side is wrong, and vice versa. What is a problem is for one to hold a view and insist that their view is right. That is where the problem is.
So there's nothing to clean up about these clauses that have taken us 7 years?
No.
Debating and ruling?
No.
Ruling 4 or 5 times?
No.
On one issue?
No.
Means the Constitution is not clear?
No. The Constitution is very clear. You have twice been elected to the office of president. You can't be elected again. Full stop. If I had become president myself, this would not be an issue. Because I'm a lawyer and I understand this issue. I didn't need a group of lawyers to come and persuade me otherwise. Okay? But the fact that you want it done your way does not mean that those who do not agree with you are wrong and you are the one who is right. So there is an aspect here of humility on our part as public leaders, as people in public life. Because we must set an example. If we insist that it is my way or the highway, then you are not a good leader. If you insist that you must always win in every situation, then you are not a good leader. Okay? If you think that you can use the word people when you mean your interest, then you are not a good leader. So I have absolutely no problem with the Constitution. Okay? The Constitution is a fine document. What we need to do is you and I to fit ourselves within the jacket of the Constitution, not to expand the Constitution to fit us. Okay? The door through which we have to walk to go and meet the Constitution inside the room is the same. Whether you are fat or you are asleep, you know, it was intended to cater for everybody to walk in or to walk through.
There's a call now for former President Edgar Lungu to walk back his political career and become a statesman. And is that something that you agree with now?
I can't speak for ECL. I can't speak, you know.
You can't advise?
For him. No, I don't think that I'm even in a position to advise.
You're not eligible?
I'm not. I'm not eligible to advise. So he has confidence around him now, people that he believes in, people that he has confidence in, people that interact with him every day. I think those are the guys that are charged with the responsibility, you know, of advising him. I don't want, you know, to, because that is now personal.
It's a public call.
I'm not,
and it is coming from everywhere. And I've even heard government officials saying he needs now to become a statesman.
No, you know, you know, we don't have
Attorney General said the same thing.
We don't have
Chief government spokesperson said that.
We don't have a
We've seen that. We've heard that from the church leaders.
We don't have a
but
poster.
Then now, you could say the same or not say the same.
No, I don't want to say anything because it's personal. That's a personal decision. If you ask for my view, I'm ill-qualified, you know, to advise him either way, because that decision is personal. When he decided
to decide to stay in politics.
Yes, when he decided to come back, you know, to politics, he didn't consult me, and I don't think that he had a duty to consult me. So what he does to his political life is entirely up to him and his colleagues in PF.